Good morning to everyone. Thank you for coming and watching this video. We are a CPO group with our partner, international partner, Horizons Corporate Advisory, and its partner, Lucia Myriam Netti. Want to present you such interesting theme that business ethic and integrity and relation with Italian clients and partners, to whom it could be useful. At first, I think to the Russian business, and in scope of communication and collaboration with Italian partners, in projects when Italian partners invest in Russia projects, and when the Russian business and capital invest in Italy. So it's like a mutual interest. And why it's theme arise? Because on the last project, when we discussed with Lucia and think to coordinate in Russia, Italian party, and asked us and Lucia how it worked and how it arranged in Russia to work with the legal ethic, and why the Russian party do to be under the terms and conditions of the European Union and Italian particularly decree about legal ethic and integrity, because they, as Italian parties, liable for such issues when they work with the foreigners, especially, and when the foreign capitals and foreign partners involved in their mutual projects, because they want to avoid such risks, risks of financial losses, reputation losses, and even criminal procedure. And in thinking issues to avoid that, they are very worried about it. And when we look through the system of the Russian parties, so they don't have it. And because of it, it's very important to prepare yourself to work with foreign capitals and foreign partners. And because it's border transaction, you should be under not only Russian national regulation, however, under their foreign regulation. Today we speak about Italian regulation and so on, and because of we ask our international partner Lucia come to us and provide a little speech, little discussion about it. And the first of the theme and the first slide is basic thesis. What does business ethic and integrity mean in context of the Italian legal system? What is it?
Thank you, Dmitry, for the questions, and good morning, ladies and gentlemen, and welcome to our webinar. Speaking about ethics and integrity, as you know, in the common practice, we may say that today it is for sure a factor. There are two factors that are fundamental in the international transactions. And if we analyze the Italian legal system about the concept of the business integrity and ethics, there are too many issues to be considered, in my opinion. The first of all is the concept of the corporate ethic code. Because if we analyze the previous years in the past, in Italy, the ethic code is not so fundamental. But in the recent years, the situation has been changed a lot. It is not mandatory by law, but it's necessary for the international transaction and also for the ordinary transaction to have an ethic code. The ethic code is in Italy a voluntary act, a self-regulatory act. There is no provision about how to draft the ethic code or who is in charge to draft the ethic code. But it is a very important issue also in the commercial negotiation, because the ethic code could provide in front of the Italian party a strong image of the company, a strong image of the values at the basis of the company in front of suppliers, clients, and partners also. So it is common in a negotiation to require to provide the ethic principle, the ethic code. So this is to say what my colleague Dmitry has already said. It's necessary to be prepared with such kind of documents. The other issue that I would point out regarding the concept of integrity and business ethic in Italian legal system is that in the recent years, I refer to the 2001, we had the legislative decree 231. And this was really, let's say, a revolution in our systems. This is the moment where the concept of the business ethic and integrity was entered in our system. And why it was a revolution? It was a revolution because since this moment, we have introduced in our systems the liability of the company, the liability of the legal entity. Before such moment, in Italy, we usually said that the company cannot be punished. So it was a strong concept, because for sure the management could be punished, but not the company by itself. With such new law, we changed totally our mind, our system, because the company can be punished. And it is interesting to see how we have arrived to such revolution. I can say that mainly Italy arrived to such revolution to comply with the international values. As you may know, Italy is one of the first founding members of the OECD. And according to the Convention of the OECD of 1997, it is necessary to fight against the corruption. So at such moment, there was not in Italy laws about this issue. So the Italian government decided to study and to issue such new regulation to fight against the corruption.
What do you think? Why in a particular time the Italian society and European society and Italian legislative bodies decide that it is already not just an ethic thing for a person with not mandatory? So it should be in written form, it should be decree, it should be strong regulation, and everybody should be liable against this. Why do you think, why it appears?
I think that it was regulated, and we had such kind of turn-off and total revolution, because the punishment of the legal entity is stronger, is a very strong remedies of the government against the company, in addition to responsibility of the managers and the legal representative. So also in front of the international community, the promulgation of such legislative decree was an important signal of our integrity as a country in general. Mm-hmm. So I think that the process that brings the Italian government to comply with the international rules, to implement the fight on the corruption, was brought by such kind of need of protection.
Okay, and how that Italian law define what is business ethic and integrity? It is just anti-corruption regulation, or it's also put any obligation to the parties to be integrity between each other, not to put in a bad position, or not provide unreal or untrue information to somebody?
Yes, there are two main issues to be considered. First of all, for sure, in the Italian Civil Code, there is the provision that requires to the parties of a commercial transaction to act in with the bona fide to act in a diligent way. So for sure, the concept of business ethics and integrity could be seen also in such kind of regulation. This is the basis of the commercial transaction. Then we have the second level, the highest level, that is the issues that our legislative decree 231 decided to point it out in a very strong way. And in this regard, there are a lot of actions that could be punished that are for sure connected with the anti-corruption fight, but that are really related to the need to act in bona fide, in a diligent way, in all the transactions.
Okay, so and what about the punishment? We understand that punishment, the company will be punished, and it would be punished because they cannot build the system and they cannot foresee in such policy that helps them to avoid infringement of the law. If they do not do this, if they do not allege to everybody and to the partners, to the clients, to their employees, that the policy of the company against such infringements, against such actions. If they do not do this, they will be punished, and Italian company can be punished, and I think their another company, their partner, local partner overseas out of Italia, can be also punished because they can be involved in such illegal, under the Italian regulations, illegal activity. And then if Italian government authority, for example, prosecutor office or internal revenue service will find such infringements, they can also send any requests to another country that their national local company infringe Italian legislation. Is that correct?
Yes, it is correct. It is important to understand that with such kind of law, we have added one level of responsibility, the responsibility of the companies, of the legal entities. And this means that in addition to the managers, the legal representative, the directors, so the heading persons, but also the employees that are acting under the supervision of such person, also the legal entity can be punished. And it is interesting to see because in this situation, we could have also the involvement of the other party. Because, for example, if you consider to have a contract, a commercial transaction between a Russian entrepreneurs and an Italian entrepreneurs, in such kind of a transaction, it is necessary to demonstrate, to prove that both parties have acted in compliance with the general rules of the anti-corruption and so in accordance with integrity and business ethics. This is a very important issue because sometimes we look at the commercial condition of a contract, but that are for sure the earth of the transaction, but sometimes the parties are not so interested in the business ethic clauses, for example. But today is important not only to draft such kind of clauses, but to protect the investor in both sides. I mean, also the foreign investor, because it's necessary to protect it and to demonstrate that it has all kind of documents to comply with the ethic and business ethic rules.
Okay, so let's switch to that decree, and that's model 231. That's what the key points that define the scope of regulation of it, who will be liable, what is the subject, who the parties of such a decree.
Yes, the main principle of such law is that the law shall punish the legal entities for the crimes put in place by some subjects. The subjects are, first of all the top management, the directors, the legal representative that have the duties to control the company, but also the employees that are under such person. So there are a large number of subjects that should be controlled to avoid such crimes. The other important issue is to who is addressed such company. I could say that it is addressed to all the legal entities, limited liability company, joint stock company. Obviously, the very small companies usually do not have such kind of documents, but it's in any case better to have because it is a way to protect themselves. It is not addressed, such law and the relevant obligation, to our government, to the territorial entities, to the public entities. And it is also interesting to see that for the listed company today, the requirements and the obligation according to the legislative decree 231 has become mandatory. So it is one of the requirements for the listing process. So it is a very interesting evolution of our system. Then the other issue that I think our entrepreneurs should consider is which kind of crimes and penalties are punished according to such a decree. We have a large number of crimes that include the international technology crimes, the abuse of the market, the money laundering, all the payment to the public officer for the way of corruption. So a large number of crimes that have all at the basis the need to be in compliance with the law, the need to observe a business ethic. And regarding the punishment, this is, I think, the main interesting issue of the law, because we have two levels of penalties. The first one is the personal penalties for the managers, for the legal representative, for the directors and other employees that could be also detained according to the law. But the other issue is the administrative responsibility of the legal entity. In such case, for sure, the legal entity cannot be punished by the detention by itself because it is a legal entity. Yeah. But there are also fines, so financial losses for the company. And one of the most interesting sanctions, in my opinion, is the publication of the decision in our Italian National Registry. It is a very important sanction, and it could cause damages to the companies. Imagine the image of the company, the corporate image of the company to be punished and to have the decision published in such national registry. So it is a very huge consequence of such a decree.
And what is it? It's how it calls when you see in the register such record that's a bad company, or what is it? How it
looks? Yes, you will see that such company has been punished because the company doesn't comply with the legislative decree 231. It is a very damage for the corporate image, and it is very difficult to cancel because you have such final decision. So it's important not to arrive to such decision. And I think that really the only way that a company has to avoid to arrive to such consequence is to be prepared. Mm-hmm. To be prepared shall mean to prepare the proper documents that according to the law is the organizational model, mm-hmm. where it's necessary to draft the corporate structure, all the requirements and the actions that the company has implemented to avoid such consequences.
Yeah, we will speak about it a little bit later. So, okay, thank you. Let's switch to the following slide and to discuss when do business ethic and integrity issues arise in the communication in work with the Russian and Italian parties. I think it covers the whole scope of relation. It doesn't matter that you're investors, you're partners, or you just order an Italian, I don't know, the picture or any any goods or services from Italy, or your Italian company and you order any goods or services from Russia. Because if your communication, your contract will be under the decree, and the legal authority find any issues, any infringement of the such decree, you also will be punished. It doesn't matter that you're investors or you're just a client contractor under the sale purchase or services contract. You should be under this decree, vice versa.
Yes, I agree with you with such description, because first of all, today, as all we know, now our commercial scenario is based on the international transaction. And speaking about the integrity and business ethic, when we can be involved in such kind of regulation, for sure there are two main issues. The first one, as you mentioned, is in case of the contract, the international contracts. Let's speak about the purchasing or selling of goods, the provision of services, the cooperation contracts. In such case, both parties are obligated to comply with the rules of the business ethic and integrity. And in this, it's necessary to formulate the clauses in the contract. First of all, to obligate the other party to comply with such principle. Secondly, to protect ourselves, because putting the clause, this means that we have inserted in the contract, we would like to comply with. So it is the fundamental act in case of commercial transaction, because both parties could be involved in terms of responsibilities. The second issue is when, for example, Russian entrepreneurs decided to invest in Italy in a subsidiary or in a joint venture with an Italian partner. And also on the contrary, when an Italian party decided to invest in Russia with a Russian party. In both situations, it is interesting to understand that our Italian jurisprudence has clarified that the legislative decree 231 is applicable also to the group of company. So it is applicable in terms of liability also to the parent company for the crimes put in place by the managers, by the senior managers, and all the subjects that we have mentioned before in favor of the controlled company, because this means in favor of the whole group. So this means that also our Russian investor could be involved in such kind of responsibility. So it is a very sensitive issue. And again, I would recall that in the recent years, our court has clarified that in case of a foreign investor, the foreign investor could invest in Italy through a contract, through a subsidiary, through a corporation, and so forth. And in all such case, it was expressly stated by the court that the foreign investor could be liable in terms of corruption, in terms of our legislative decree. So it is a very important issue to consider, because also the foreign investors could be involved. Mm-hmm. And from the Italian side, if the Italian party will decide to invest in Russia with a Russian partner, this is the same, because the Italian party should be sure that all the principles in the legislative decree will be applicable in the new entity.
Yeah, for sure. So, and the final, I think it's very easy how to avoid. Yeah, you said it before. However, how to avoid to be liable under such decree and avoid any legal issues concerning it. I think that's the first of one is for sure to provide good preliminary compliance of the partner. So especially for the Italian clients and partners, to provide preliminary legal compliance on the Russian companies, because Russia don't have such system, and because of it, you should be sure, as you said, that your partner are clear for the Italian authorities if they will check their relation. The second is to build the corporate structure and to bring it in accordance with the requirements. The corporate, it should be a supervisor or who provides internal compliance, such an officer in the company who duplicate the powers of the state authorities, but inside of your company, and provide such kind of supervision online day by day. And the second is to prepare documents, a policy of the company that even if your employees or managers will be catched under the infringement, that the company may say, we against it, our policy that we against such actions, and such actions, it's not official position of the company. However, it's just action of such particular person. We are also not approve such actions, and of course it should be liable internal in the company, and if it's possible under the legislation of the criminal legislation and so on. However, company do not involve in this.
Yes, absolutely. I think that these are the main three issues that the company should think about and should implement to avoid the risk and damages of our legislation. And in this, for sure, in all the international transaction and investment, first of all, the analysis of the business model and the structure of the corporate investment is fundamental. And after this, it is absolutely necessary to prepare the proper batch of documents to be presented, to be implemented in the company, because this is only the sole instrument that we can use in case of a claim against legislative decree, in case of a claim against issue of corruption, for example. So it's necessary to be prepared and to have such kind of documents that include the organizational model that we have mentioned a few minutes ago, and to appoint, for example, some supervisory body to verify the implementation of such model. And in this, how the company could operate to prepare such documents. For sure, the company should have been supported by professionals, because it is not easy to draft such documents. And first of all, it's necessary to draft documents that could be really enforceable. I think that in this is our power as lawyers, and this is the way that we as Horizons and CPO Group work every day to provide documents, not to complicate the issue, but to be enforceable, to protect the investors. So in this, we are absolutely at disposal for both, for the Russian side, for the Italian side, to find the best solution.
Okay, so thank you very much. I think so. If you have any questions to me or to Lucia, please send it to our email. And if you have any interest in further information, or you want to any theme that we will discuss in the future, so please send it to us. And if it be useful, we will prepare such materials to you also. Thank you very much. Thank you to you, Lucia, for your participation. So
thank you.
Yeah, have a nice day. Goodbye.
Thank you. Have a nice day.
Bye-bye.